Hi, everyone. I think we will get started and people will just keep joining. Welcome. Thank you for joining the New York Women's Bar's Reproductive Rights and Women's Health Committee and the Matrimonial and Family Law Committees for our webinar tonight. We are so excited to have three of the top women in their respective fields join us for an interdisciplinary panel entitled Compensated Gestational Surrogacy is Legal in New York State. Now what? On our panel tonight, we have Alexis Cirel, a prominent family law attorney who recently launched the Fertility Law Group at Warsaw Burstein in New York City. Dr. Anat Brower, the IVF director at Shady Grove Fertility. Dr. Brower is a board-certified reproductive endocrinologist with extensive experience in treating all medical and surgical aspects of infertility. And also joining us is Dr. Georgia Whitkin, Director of Psychological Services of RMA of New York. She is a clinical psychologist and expert on infertility, egg donation, egg freezing, and therapy for couples. So now I will turn it over to Alexis Cirel to start the program.
Thanks, Alex, and thanks so much, everybody, for joining tonight to talk about this new surrogacy law. Many of you know me, and you know that kind of obsessed with this topic, both personally and professionally, having lived through it as a patient and a client on a personal basis, having advocated long and hard to change New York's antiquated ban on surrogacy, and now having the privilege really to sit on the other side of the desk and provide legal counsel to other intended parents who are seeking to build their families through this extraordinary act of science and kindness. I also want to thank this chapter of the Women's Bar in particular and the Women's Bar at large, because you all know how integral our organization's support was to really getting this law passed. And so for all of you who contributed to solidify that support, thank you. I was thinking about how I wanted to structure tonight's program and really make it relatable and meaningful for our members. And it struck me that really a holistic understanding of what surrogacy is will mean more to this group in particular, especially about the impact on women in New York. And it's really equally important, if not more important, to understand the je ne sais quoi, really, of surrogacy, rather than just the nuts and bolts of the ins and outs of the statutory scheme, which we can all, read and study. This is really because surrogacy is the embodiment of the expression, what we say, it takes a village. It's not just the uniquely trusting and amazingly rewarding relationship that forms between surrogate and intended parents, but really the interdisciplinary collaboration that goes into the surrogacy process makes it really the incredible journey, as it's called, that it is. So I'm really so excited that Dr. Brower and Dr. Whitkin joined me tonight to be part of this interdisciplinary panel. You really can't understand the legal aspects of surrogacy without the medicine without the psychology, and around we go. So I just want to give a little bit of background in terms of where the law was before the new Child Parent Security Act came into effect earlier this month. We'll do a little bit of high level about what the law is now, then we'll quit the boring stuff. We'll go to the medicine and the psychology, and we'll come back to some of the nuts and bolts of what surrogacy agreements are and how to obtain orders of parentage afterwards. So February 15th, 2021, the Child Parent Security Act became law in New York. It's codified as the Family Court Act. It's codified as the Family Court Act, Article 5C, and it truly is revolutionary. It's sweeping. It applies to children conceived through all forms of assisted reproductive means, including third-party arrangements, which include gestational surrogacy. Gestational surrogacy is distinct from genetic or traditional surrogacy in that the woman, the surrogate, who enters into the surrogacy agreement is not genetically related to the child that she carries, i.e. it's not her egg that's used. And she enters into this arrangement with the intent that someone else, we call the intended parents, will only be the legal parent of the child. The new statute repeals what was formerly Domestic Relations Law Article 8, which was our ban in New York on surrogacy arrangements. The ban became law in New York following the infamous Baby M case, which was a case out of New Jersey dealing with non-gestational surrogacy, but what I referred to before as genetic surrogacy. In that case, the woman who was the surrogate was also genetically connected to the child whose pregnancy she carried, and notwithstanding an agreement with intended parents that they would be the legal parents, she, after birth, changed her mind, sought custody, and years of a drawn-out custody battle ensued. And there was legislation both in New Jersey and in New York that resulted in the ban that was, I apologize there, in the ban that was in place prior to February 15th of this year. The new statute repeals this. The new statute repeals this, and in its place, it's a regulatory scheme that's carefully crafted and based on really best practices for enforceable surrogacy agreements in other states and model acts throughout the country. It defines legal parentage with reference to intent and consent to be a parent, rather than traditional principles of biology, marriage, and/or gestation. It allows intended parents, regardless of whether one or both has a genetic connection to the child, to enter into an enforceable contract and to compensate the surrogate and obtain a pre-birth order thereafter. After Dr. Anat speaks and Dr. Whitcomb speaks, we'll talk a little bit more about the intricate statutory requirements for the surrogacy agreements. But just so you know, it scrupulously supervises these arrangements and prescribes in detail the necessary elements of what will go into a surrogacy agreement, who the eligible participants are, and participants, I mean surrogates and intended parents. And we'll talk about the Surrogates Bill of Rights, which is really a gold standard nationwide. We're the only state in the country now who has legislation governing surrogacy that includes a Surrogates Bill of Rights. And really it just enumerates specific substantive rights of the surrogate that must be included in every agreement and cannot be waived under no circumstances. So just very quickly, because I get this question a lot, right? What does it mean to be eligible to participate in a surrogacy arrangement in New York, as opposed to what New York intended parents, for example, have done until now, which is to go out of state to do this. If you want to take advantage of New York's law, what must you do? What must you satisfy in terms of being an intended parent? What must you satisfy in terms of being the surrogate? For IPs, intended parents, at least one must be United States citizen or lawful permanent resident. At least one has been a New York resident for at least 6 months. IPs can be single individuals. They can be unmarried intimate partners. They can be a married couple entering into the contract together, or it can be an individual spouse in a marital relationship if they've been physically separated for 3 years or living separate and apart pursuant to a separation agreement or divorce judgment. The surrogate requirements are that she must be at least 21 years old. She's a United States citizen or lawful permanent resident, and she has to be a New York resident for at least 6 months if one or more of the intended parents is not. Finally, and really most importantly, and this is a perfect segue into the next portions of the program, surrogates eligibility to enter into an enforceable agreement in New York 100% is conditioned upon her undergoing a medical evaluation and giving informed consent following an explanation of all the risks, psychological and medical, to her that are involved in the process. This must be recited in the body of the contract itself. And with that, I will turn it over to Dr. Brower, and we'll talk about some of the medicine, and I'll be back. Thanks.
Thank you so much, Alexis, and thank you guys all for having me. I'm just going to share my screen here. Do you guys see it? Perfect.
Yep.
Awesome. So I'm going to take you on a crash course of IVF and gestational surrogacy. I promise you did not learn this in law school, and I actually didn't learn this in med school either. So just a little bit about Shade Grow Fertility. So I'm located at Shade Grow Fertility, New York, where I serve as the IVF director. SGF is one of the largest fertility programs in the country. We have multiple regions. New York is the 8th region. We're located in New York, Florida, Georgia, Maryland, Pennsylvania, Virginia, and DC. Shortly in Colorado, and we also have a lab in Santiago, Chile. Because we're located in so many states, I have been able to continue doing surrogacy. Originally I trained at Cornell in the city, where I had no GC training at all because it's located in Manhattan. And then I joined NYU to help run a lab in Greenwich, Connecticut. And because our lab was located in Connecticut, we built a GC program there where I did many surrogacy cases for the last 7 years before I opened SGF New York. And that's really where I learned all about surrogacy, because many centers in the city don't do it because you can't. But because our lab was in Connecticut, we could do the transfers there and help patients that live in Manhattan. When I opened SGF New York, I continued offering surrogacy because our patients, our intended parents, are able to go have their embryo transfers in our Pennsylvania lab, which is a couple of hours away, or our Maryland lab, or really wherever their GC chooses to go have her transfer, because it's out of New York. Now that this law has passed, we're excited to make this a little bit more accessible to our New York patients, because all of the travel is an additional stress to an already very stressful infertility journey for many of our patients. So we're very, very grateful to Alexis and many other attorneys that have been involved in passing this law. So first, let's talk about some definitions. And Alexis kept mentioning IP and GC. So IP is intended parents. So those are the parents that are donating their gametes, their egg or their sperm, and GC is gestational carrier. And more recently, in the last few years, we've been using the term gestational surrogate. But as Alexis pointed out, it's very important to understand that we're not talking about traditional surrogates. We're talking about gestational surrogates that are going to be carrying someone else's gametes. So what is the process? First step is consulting with your physician, screening and evaluation of the intended parents. I kind of look at this as a two-step journey. The first half of the journey is creating the embryos, and the second half of the journey is matching with your gestational carrier and doing the frozen embryo transfer cycle with her. So first step is doing IVF and creating the embryos, which is required to create embryos, IVF. And the second part is finding the carrier. And once you found that carrier undergoes medical psychological screening, and a follow-up plan and eventual transfer and hopefully pregnancy testing. So let's just go through that. So the first step is really consult and evaluation with your physician. And at the initial consult, many patients who have reached the point of requiring surrogacy have already been through, many of them through an infertility journey, unless they're coming to me because they have lost their uterus in a traumatic event, or can't carry for medical reasons. But usually there's some kind of fertility workup involved, which is basically looking at ovaries, inclusive of quantity and quality of eggs, sperm, and in usual infertility cases, we look at the tubes in the uterus, but in these cases, we're using a carrier. But that's kind of the basic workup. Most women will undergo an evaluation for egg quantity. The most commonly used hormone is blood test is called AMH, anti-Mullerian hormone, which gives us an idea of ovarian reserve, or how many eggs are going to be able to get retrieved with an IVF cycle. And these other evaluations that we usually use for women with infertility, like a saline sonogram and a hysterosalpingogram, et cetera, will be applied to the carrier. So I'll talk about that in a minute. And of course, for the males, a semen analysis to look at sperm. So the first step is really creating the embryos. And there are couples who use gestational surrogates or gestational carriers who are using their own eggs. So they're doing autologous IVF, or there are couples that are creating embryos from donor egg or donor sperm. No matter if you're using your own eggs or sperm or you're using donor egg or donor sperm, the medical process is really the same. So to understand anything we do in IVF, you should understand just how a regular cycle works. And in medical school, when they would put up this like crazy slide of all the hormones that go on in the month, it was really dizzying. And it took me a while to kind of like boil it all down to this slide, which I go over with every single one of my patients. So when you start, and when I say cycle, I mean period to period. So the beginning of a cycle, you start off with all these little resting eggs, and they're housed in little sacs of fluid called follicles that you can actually see on ultrasound in the ovaries. And your brain makes this hormone called FSH, follicle stimulating hormone, that does what it says it does. It basically stimulates one of these follicles to grow. And as it grows, it matures. As it matures, it makes estrogen. And that estrogen, when that follicles reach peak maturity, tells the brain to stop making FSH. That cuts off the supply of these little guys. And that's what controls your body to grow only one egg every month. Then it tells the brain to make this other hormone called LH that leads to final steps of maturation and eventual ovulation of the egg, at which point it can meet a sperm, can create an embryo, and can implant in the uterus. So natural conception, just like an image of it, basically ovulation, meet the sperm in the tube, make an embryo, go to the uterus and implant. IVF is a different ballgame. So with IVF, one of the whole purpose of IVF is efficiency. So we don't want your brain to make this hormone to just grow one egg every month. We basically stop the brain from talking to the ovary, and we give you FSH directly with the goal of recruiting multiple of these eggs, multiple of these follicles. We then follow the patient, whether it's a donor or someone doing autologous IVF, over a period of about 2 weeks. During this time, they're taking injections of the FSH, and they come in every 2 to 3 days to have ultrasound and blood work where we can actually measure the follicles. And we know that when a follicle gets to be a certain size, we trigger the final steps of maturation. But instead of letting her ovulate, we take her for an egg retrieval. So this is in vivo, so natural conception, and in vitro, where you're basically retrieving these eggs. And I'll show you a picture of that in a minute. So the first step, as I said, is just the stimulation and the monitoring. Takes about 2 weeks, injections every night. You're in every 2 to 3 days, getting this ultrasound and blood work. When the follicles get to be the certain size, we give you this, what's called a trigger shot, which leads to the final steps of maturation. And then we move to the egg retrieval. So an egg retrieval happens about 35 to 36 hours after the trigger shot. And it's about a 20-minute procedure. The patient's under anesthesia, so it's IV sedation. It's usually something like propofol, which is like what people get for colonoscopies. And we use a transvaginal ultrasound probe with the needle guide at the end, and we suction out all the fluid from all the follicles. So you can see these fluid-filled sacs. And here, this little bright white line is the needle guide. And we actually aspirate all the fluid from all these follicles, and within the fluid live the eggs. So here you have a picture of an egg. And then the embryologist takes the eggs and fertilizes them. And there's 2 ways to fertilize eggs. There's conventional insemination, where, as you see here, you put an egg in a droplet, surround it by 50,000 sperm and let them do their thing. Or there's ICSI, intracytoplasmic sperm injection, where you take a sperm and you inject it into the egg, and decisions on which one to do is really up to the clinical picture. We then culture the embryos. Our goal is to grow them out to a stage called a blastocyst. So if you look here, this is the day after retrieval. You have an egg that's been fertilized by a sperm. You have here a nucleus from the egg and a nucleus from the sperm. And now it's considered an embryo, and it starts to divide. Our goal is to get to this over here, the bottom right corner. This is called a blastocyst, and an embryo usually gets there on about day 5 to 6. It basically has 2 cell layers. It has an inner cell mass that becomes a fetus and an outer cell layer that becomes a placenta. and they're genetically equivalent about 99% of the time. So you can either just, if you're using a surrogate, you can either just freeze that embryo as is, but many people decide to do genetic testing on the embryo. So when we look at women's ability to conceive, it's really based on egg quantity and egg quality. And when I say egg quality, I mean genetics of the eggs. And egg quality is dictated by age. So as women get older, we not only lose eggs, but the eggs we retain age. So, and there's no blood test, and an egg with the wrong number of chromosomes either won't fertilize, will fertilize and not implant, or will fertilize, implant, and lead to a miscarriage. We know from testing hundreds of thousands of women at different age groups through IVF, through testing their embryos, that even at 30, around half your eggs and therefore embryos will be chromosomally abnormal. By 40, it's about 90%. And that's where this whole idea of PGT, pre-implantation genetic testing, and in this case specifically, it's called PGTA, pre-implantation genetic testing for aneuploidy. It's also known as PGS, pre-implantation genetic screening. That's where this whole thing came from. The idea of you can't just tell if an embryo is chromosomally normal or not by looking at it. So you can actually take some of these outer layer cells, the trifectoderm cells that become the placenta, freeze the embryos, send the cells off for testing. You get a report back 2 weeks later with each embryo and its chromosomal complement. And now you know which is normal and which isn't, and you know which one is more likely to lead to a pregnancy and less likely to lead to a miscarriage. Whereas a younger person may not choose to do this if they are planning on transferring the embryo into themselves. I strongly encourage intended parents who are planning on using a gestational carrier to do this testing, because now you're involving a third party and you really want to minimize risk of miscarriage and maximize chance of pregnancy. So this is called PGTA, pre-implantation genetic testing for aneuploidy. So some nuances when you're creating embryos specifically for transfer into GC really revolves around timing of FDA testing. And this FDA testing includes mostly infectious disease testing, also full physical exam on the patients. And so for males, meaning whoever the partner is that's donating the sperm, they will require FDA testing within 7 days of sperm production. And that's very specific. And 7 days is like a very short timeline. So most centers, if they're using sperm to create an embryo that they're going to use in a GC, require cryopreservation of that sperm, require that sperm to be frozen so as not to miss the timeline. At SGF, we definitely require that. You can't use fresh sperm for creation of an embryo for a gestational carrier, because we want to make sure that we've done that FDA testing. And also, let's say they need to create a new batch of embryos, you don't want to have to do a whole new set of FDA testing because it can get expensive for the intended parents. And so they freeze multiple vials at one time. We do the FDA testing at the correct timeline, and then they can use it even if they need to create future embryos. And for females, it's within 30 days of egg collection or egg retrieval. So now you have your embryos, they're in the freezer, and now it's time to move on to the second part of the journey, which is matching with a gestational carrier. Now, because matching with a carrier can take some time, many IPs decide to progress in this process concomitantly, so at the same time. Counseling patients on this depends on their clinical picture, because I don't want someone to, as a physician, to invest their time and finances into a carrier if, let's say, they have very little hope at making an embryo. So let's say it's an intended parent where the female is 44 years old and has a very, very low egg quantity, and she's not willing to use a donor egg. The chances of her getting a viable embryo is in the single digits. So in that case, I would say, okay, let's get the embryo in the freezer first before you kind of delve into the gestational carrier process. But if it's someone who's using a donor egg, like a male couple, or someone who's very young with a great ovarian reserve, and I think they're going to do really great, they can start at least looking into GC. So there's many different ways to find a gestational carrier. I generally tend to pretty strongly recommend using an agency. And that is because there are so many moving parts to this, not only finding the carrier, and an agency has the resources to vet that carrier more than someone finding a carrier on, say, like Craigslist or Facebook, which people have brought to me. So it's not only vetting, but it's also setting up visits for that carrier, coordinating with the clinic for that carrier, setting up insurance for that carrier, plugging them into legal resources, et cetera. So I generally tend to recommend an agency. And the first step is really, there's an initial match with the intended parents. And then as a physician, I do a preliminary medical review of records. So they send me all of her prior deliveries. They send me any medical history. A lot of times we'll also do, if she hasn't had a delivery in a while, we'll do a preconception checklist, all the preconception labs ahead of time, so we make sure there aren't any red flags. At SGF, our minimal requirements for GC are they have to be under 43 years old with a BMI of under 32, maximum prior vaginal deliveries of 5, maximum prior C-sections of 2. And of course, as you will see, we do require them to have psychological screening as a part of even the preliminary clearance. So once they're preliminarily cleared, they come to us for what's called a GC day. Now, this has been a little bit different with COVID, but in general, on the GC day, the intended parents and the gestational carrier come to the clinic. At that point, the gestational carrier is already on a birth control pill. I meet her, I do a full consult. Usually we also require that the partner of the gestational carrier come with her. We have had single gestational carriers, but because it's a support system is so important with a carrier, many of them are married that end up coming through the agencies. And so I interview both the carrier and her partner. I do a full physical exam. At that point, I also do an FDA physical and questionnaire. So the FDA does not require, the FDA requires that the intended parents, like the donors of the gametes, have FDA testing with labs and a physical. They don't require the GC to have the same testing. However, ASRM, which is our governing body, recommends that GC have the same testing. And so we do follow ASRM guidelines. We do the FDA questionnaire, FDA physical, and FDA testing on the gestational carrier. She also has toxicology screening that day, all of the infectious disease screening. We do a mock embryo transfer and a saline sonogram, which I'll show you in a minute. And at that point, we also have our psychological screening. So the day, it's really kind of a full day because I meet the carrier. While I'm with the carrier, the intended parents are meeting with a psychologist separately. I then meet with the intended parents to talk to them about how things went with the GC. And at that time, the gestational carrier is meeting with, and her partner are meeting with a psychologist separately. And then at the end of the day, they all meet together. And that's a really important meeting that Georgia, I'm sure, will talk about a little bit more. Also on that day, we do all of the consents with the carrier, and we do a medication teach class with the carrier as well. So what is this mock embryo transfer and saline sonogram? Basically, I don't want to be surprised on the day of a transfer that I can't get the embryo into the uterus. That would be a very bad thing to happen after all of this emotional and financial investment. So we always take a trial, we put a speculum in and we do a trial transfer catheter to make sure it's nice and smooth. And here you see, this is the catheter that we use, and you see it brights up, it's really bright on the screen. And with the same catheter, we infuse saline. So you can see this black stuff is all saline, and we actually take 3D pictures of the uterus to make sure that it's a really nice home for an embryo. So after that GC day, it takes about a couple weeks to get all the testing back. If the GC and her hadn't done the objective psychological testing, that also takes time to get interpreted. We wait for the report from the psychologist, as well as all of the testing, the toxicology, the infectious disease, all the FDA testing. And I have a follow-up with the intended parents. We review all the results and we set up her cycle. Of course, nobody can cycle until there is complete legal clearance. Agencies do this in different ways. Some agencies have contracts before clearance. That always makes me a little bit nervous, because if you come up on something on the day of the GC day, then you don't move forward and you've already potentially invested in those contracts, many agencies have ways of protecting their intended parents from additional costs. So I always encourage my intended parents to interview agencies and ask if they do contracts before or after clearance. And if contracts are done before clearance, to have a mechanism to get some of that investment back or paid forward into a new cycle. So now everything's cleared, we're getting them set up for the cycle, and the frozen embryo transfer cycle for a carrier is actually much easier than the retrieval cycle is for the intended parent. So first, you do not want their brain to tell their ovary to grow an egg, because if you're letting them ovulate, I've signed many affidavits that I say, I promise you, I swear that this woman didn't ovulate, and this is definitely the embryo belonging to IPs so-and-so and so-and-so. So the first thing we do is give them something called Lupron, which is, it's a GnRH antagonist that basically shuts the brain down from making FSH and LH. It kind of puts you into a chemical menopause. It's something we use in IVF cycles, or we used to use a lot in IVF cycles, less so now, but we give it to them to just stop the brain from talking to the ovary. And now we mimic this cycle. So we give them oral estrogen. You can do estrogen in oral or patches. There's also injectable estrogen that some programs use. And so they're on estrogen for a minimum of 2 weeks. And the purpose of that is to thicken the lining of the uterus. And once the lining looks good to go, we start progesterone, right? Which is what your body would normally make in a natural cycle. And we do the embryo transfer on the 6th day of progesterone. If the GC is coming from out of town, usually she doesn't fly in until we know for sure that her lining is good and she starts the progesterone. So it's a lot of logistics, but from a medical perspective, it's really easy. The embryo transfer itself is about a 5 to 10 minute procedure. The only pain really associated with it is the discomfort of a speculum. Otherwise, they shouldn't really feel the catheter at all. You're not under anesthesia for this. And they do their transfer, they rest in the recovery room for 20 minutes, and then they go along their way. SGF and myself as a physician, we are huge proponents of elective single embryo transfers. I have many intended parents coming to me asking for twins because the process is so expensive that they kind of want a 2-for-1 deal. And my answer is categorically no, not in such a harsh way. I just try to explain it in a way that makes them understand, and at the end of the day realize that an elective single embryo transfer is the way to go, only because twins are so much higher risk, with risk of preterm delivery and preeclampsia for the gestational carrier and gestational diabetes and all the complications that come with pregnancy. And so at the end of that conversation, usually I get, okay, you're right, I'll do a single embryo transfer. And it's important to note that for an REI, like for a physician working with IPs and GCs, I really view myself, and I spend time explaining this to the GC in our consult, that I'm really the doctor of both entities. And so it kind of behooves me to look out for both entities and make sure that everybody's comfortable. I'm doing the best, I'm making the best medical decisions for both parties. So inclusive of an elective single embryo transfer. 12 days later, we do a pregnancy test. We repeat it every 2 to 3 days and hopefully have a pregnancy. So that is the process. And I just want to thank you all for what you do. It's really humbling to be in a room with wonderful, powerful women. And I had to Google this in the last minute, and I just thought it was so cute. What everyone's perspectives of what an attorney is, and really, this is really what you do. So thank you guys.
Great. Okay, Georgia, I am going to try and share my screen for you. So now Dr. Witkin is going to talk about the psychology aspect. You can tell already how much of the interdisciplinary complementing of professions that happens just in terms of the overlaps between law and medicine. And now we'll just blow your mind even more. So let me see if I can do.
In the meantime, let me chat just for a minute while you set it up. So I don't even know how to do that. So I want to tell you how I came to this so that as I talk about things, you'll really understand the perspective that I'm bringing. I was in psychiatry at Mount Sinai for years, and I was studying women and stress because everyone else was studying men and their heart attacks and their type A personalities. And I've written 13 books on women in stress and children on stress. So when OBGYN started a fertility unit a long time ago at Mount Sinai, they said, let's get that woman from psychiatry who deals with women in stress, because that's what we're going to be dealing with, you know, thinking that, of course, men never have fertility problems. So it was very long ago that I joined both departments. I'm still in both departments, psychiatry and OBGYN at Mount Sinai, but RMA became a separate branch, and I went with RMA as their director of psychology, wellness, psychiatry. But in addition, I'm with Progeny. If you know about Progeny, we're talking about fertility benefits. And they have also, through the reimbursement programs, supported surrogacy. So I've been writing about surrogacy. I have a column in Psych Today called Chronicles of Infertility, and been dealing with, you know, altruistic gestational surrogacy, not paid, for years. And I am thrilled for the whole LGBT community, for all of the women who will need this, that this has come to be. And I thank you, Alexis, and your whole group and the committee and all the work that you've done. So let me talk about the psych side. And now you know kind of where I'm coming from, which is a lot of stress, knowing about it and having it. So the next slide. This is, as Dr. Brower was saying, this is step one. We have a third-party team that looks at all of the profiles of everybody who's being submitted to us as possible gestational carriers. We look at their pregnancy history, their genetics, their education. Do they have children? And we know that they're supposed to. How many do they have? Their partner. How is their partner going to handle things while they're pregnant for 9 months, the medical records? And then we build our own. We add drug screening and physicals and something called the PAI, which is Personality Assessment Inventory, which really cannot substitute for face-to-face interviews. But what's interesting is it has many scales. And there's a depression scale, and you don't want to give anyone hormones if they're high on the depression scale. If they're high on the psychosis scale, you really feel like you have to reassess if they really quite grasp what they're doing. And the rest of the scales are not too relevant, except for one which is fondly called the lie scale. If you make yourself look so good that you're just off the charts, what PAI says, sorry, nothing you're saying can be believed. And we're asked often by patients, how do we know if people are telling the truth? One of the ways is the PAI. The last step, according to ASRM, is that, as Dr. Brower was saying, both the IPs and the GCs are supposed to get psychosocial education and counseling. Notice it doesn't say therapy and it doesn't say emotional evaluation. It says education and counseling, and I take that very seriously. So what we're offering is information and orientation, support. I'm there for support during the whole thing. They can call me, they can text me. It can be the IPs, it can be a couple, it can be the GC. And finally, I'm there for cognitive restructuring. If you haven't heard it before, it's one of my favorite terms. It's a way of helping people see, notice when their thinking is negative and replace it by something more accurate. And when it comes to these interviews and these interactions, it can be a game changer. And at each point, I will point out the cognitive restructuring. And by the way, these are all techniques you can use at home, with your children, with your partners, with your parents. So what I did is I looked for not everything that we do, but what attorneys might need to know or find interesting with regard to the issues, the questions, and the concerns that we see during the interviews. So if we go to the next, Alexis is doing it for me. So I'm just going to say, if we go to the next. Okay, so I'm going to say, Dr. Brower, that in this case, I'm seeing the IPs and the GSs together first, but it can go either way. You know, they can be with you and I'll see just the carrier or just the intended parents. But let's say when I see them together, here's the communication. Number one, I want them to be clear that this is a fertility procedure which IVF has made possible. Because of IVF, a woman without a uterus or abnormal uterus, oncotherapy patients, the LGBTQ communities. Single men can now use their own gene pool, and that's the key, their own gene pool to achieve parenthood. So what's very important is that they must understand this is not like adoption. Nobody is giving away their child. Nobody has gestated, built a child that is genetically theirs and is giving it away, because the GS has no genetic connection to the child. Number two, this is not like ovum donation. A lot of people know about ovum donation. With ovum donation, the recipient gets not just one gene donation from the egg donor, but double, because every woman on the face of the earth starts her baby with outside donation, and that's the male sperm. So with ovum donation, she's getting double donation, an egg and sperm. And this is the opposite. The IP is using her own genes. So it's really important they understand that difference. And number two, if they've been through ovum donation and know about it, they probably know that you get very non-identifying information, because a donor of eggs is not giving you necessarily what shows up in her. Her gene pool is over 9 trillion combinations that are possible. So there's no need for specific information, but with surrogacy, you're likely to have a lifelong relationship, with your carrier. So it's a very different picture. Next. And that's what I emphasize next. Here's why gestational surrogacy is so different. And this is what I call cognitive restructuring. What I make sure the IPs and the GCs know is that the child is already 3 to 5 days old when it's transferred to the GS. As you heard from Dr. Brower, it's already a blastocyst. Every cell in that blast has the same instructions that are genetic, and has come from the IPs. So the GC is nourishing it from zygote to fetus, but it was already created when it was transferred. The child, the myth is that, the child gets the blood of whoever is pregnant. Her blood does not flow through the child. The child makes its own blood, its own tissues, its own muscles. Every child does. And it's following genetic instructions from, not the GC, but the IPs. And I have lots of patients who bring up epigenetics. Oh, I've read that while the baby is in the GC, that her DNA is mixing with the baby's DNA. That's not the way it works. And there might be questions afterwards that Dr. Brower could answer. But basically, the GC's environment can turn on and off some of the DNA, but DNA is not transferred. So what's so unique about this is the medical genetic history of the child is untouched. It inherits from both mother and father, for better and for worse, their medical history. Number two, their familial history. The mother of the IP, if it's female, is the grandmother. The mother of the IP, if it's male, is the grandmother. There's no difference in family. And if they do 23andAncestry.com, they will get the same gene pools as the IPs. Next. So let's talk about talking to the GCs or the GSs individually. When I see them alone, of course, I'm going to gather some information. And not only that PAI that I was talking about, but, and please don't tell, but I give them 2 parts of the Wexler Adult Intelligence Scale, the WAIS. I give them common sense and concept formation. Now, it's not to measure their intelligence, but I was looking for a good measure of how much they will understand all the concepts that we're talking about now. And over the years, I found those 2 short tests, which cannot predict full IQ, were very, very useful. So I give them those 2 tests to make sure that they really know, for example, how an axe and a saw are alike, they're both tools. How a statue and a painting are alike, they're both art. Simple things like that. But I also go through the following questions with them. How were you approached, or did you reach out? Number 2, why are you doing them? Bioethics are very, very important. We want to make sure they're not desperate, they're not being coerced. What would make you terminate. If I'm correct, Alexis, in the new law, the GC has the right to terminate?
Absolutely.
Absolutely.
It's part of the Surrogates Bill of Rights, correct.
Right. And we make sure, of course, they receive that. This is a big part of the discussion for me. Even if you don't want to terminate, what would be for you the factors that might make you do it? Is it something about your own child? Is it about your own health? Is it about your relationship? And you can really measure. And much of the time, I will say, listen, this has to be discussed when we're all together. This is not something that you can just tell me, and don't be ashamed of it. And it happens, but we have to know what your parameters are. And also, to me, very important is who is in their support system, because this is not easy. I also want to know who has told them that they shouldn't do it, because that can have a big effect on how well they go through it and how they're going to relate to their IPs. What I then do, which I will share with you, is I say to them, typically before they even see me, I want you to either write or find a quote that for you explains why you're doing this, aside from just the money, because there are other ways of making money. And here are some of my favorites. Greatest good is what we do for others. It's a quote from Mother Teresa that came from one of the GCs. However motherhood comes to you, it's a miracle. Believe it or not, that's from the actress Valerie Harper. Here's one even better. Little souls find their way to you, whether they're from your womb or somebody else's. That's from Sheryl Crow, the singer. They say it takes a village to raise a child. Well, sometimes it takes a village to have and make a child, from Sarah Welsh. My favorite of all, in it for the outcome, not for the income. And that's a quote from a t-shirt in Canada. So wherever they get their inspiration, I want to know what it means to them. And those are some of the examples. Next. Now let's talk about cognitive restructuring. When I'm talking to a GS or a GC, I want them to be clear that they are donating the use of the uterus to the IP, not to the child. And you would be surprised. I would say at least 50% of the GCs I see are still seeing themselves giving their uterus to the child. And it's very important when I talk about cognitive restructuring that the way they see it is really clearly a relationship to the IP, or it gets very confusing later for them and for the child and for the IP. I want them to be clear that they're being paid for their time and their effort, and they're doing something difficult and wonderful, but they are not being paid for a baby. And I know the law underlines that as well. So the bottom line is the GC is not their mother. And we talk about that. They are, under our law, I know they've all been mothers, so they do typically understand. I also encourage them to understand why it'll be the IP that decides when and how the child is told about this whole process, because some want credit and some want it very early, and some are involved and some are telling the IPs, I think you should be telling, I think you should be sharing, it's great to be open, but it's really up to the IPs to decide when and how. Next. So the last thing that I cover when I'm alone with the GCs is I do give them a chance to say anything that they would not want to say in front of the IPs. This is not secrets, but this might be things that they feel, since they're going to have probably a lifelong relationship with the IP, they don't want to say in front of them, you know, listen, it really is very physically demanding and I really am a little nervous and I'm worried about if I have mixed feelings, is that normal? If I bond with their baby during pregnancy, what do I do about that? If I really feel some bereavement and sadness, you know, when I give the baby up, what am I going to do about that? They don't want to talk about that in front of the IPs. And my answer to them, as you can see on the screen, is normal, normal, normal. We're actually biochemically programmed to bond to any baby that we gestate, which makes sense because babies are, and humans are just so dependent for so long and so difficult that without that bonding, you know, after 2 weeks, we'd probably pass the baby to somebody else. But Once they understand that those feelings are normal and that they can be observed but not acted on, expected, and if you can see at the bottom, the studies indicate that the feelings lessen within weeks. It is not dramatic or drastic, even though the naysayers always talk about it. It really turns out statistically not to be a problem. Next. So now when we're talking about the IPs, and I'm seeing them without the GCs, here's the next cognitive restructuring. I find it's very important that they understand that their carrier is not a passive incubator. When you're pregnant, you're not eating for two. The baby does not have a digestive system. And when you're sleeping, it might need building blocks. There's only one way to make a baby on the planet, and that's a woman's body has to build it. And the GC is building it. The baby's going to take her protein and her sugar, 30% of her calcium, her minerals. So I encourage the IPs to understand that because her environment's going to interact with the baby for 9 months, you're choosing a GC based not just on their personality, because you have good vibes, and not just on their spirit, and not just because you're going to be involved with them for perhaps the rest of your life, but on their physical health and their experience in parenting, because they are going to be your GC. Look at that number, for 6,384 hours. And you want someone who has good health, who's going to be able to nourish that baby well and knows what's coming. And as a tip, by the way, I suggest to the GSs when they're not with with the IPs when they're not with their GCs, if you're going to give them a letter of thanks, if you're going to give them something besides the reimbursement, do it at the time of transfer, not at the time of birth. Because again, you want to be clear that the transfer is when you say, thank you for trying to help. If you do it after the birth, the message is thank you for the baby. And again, this is your baby if you're the IPs. Next. The IPs also will always talk about, I have mixed feelings. Is that natural? I might not have mourned my own eggs yet. And I say, first of all, if you in college read about Kubler-Ross's stages, need stages, you go through mourning and then you go through, it doesn't exist. There's not one piece of research that ever backed it up. People have mixed feelings, particularly women. We can be sad we're not using our gene pool, but happy in some ways we're not because it has cancer or it has Alzheimer's. We can be thrilled that we have a GC. We can be happy that we are using our genes because our family is so bright. I mean, whether it's ovum donation, whether it's GC, whether it's any kind of altruistic surrogacy, mixed feelings are normal. Women are capable of it and do well with it. Stress is normal. I told you I wrote 13 books on stress. I can condense 13 books into one sentence. When your sense of control goes down, stress goes up. And you are defining, as Dr. Brower said also, what this is all about. You're letting go of control. Somebody else is carrying the child. It's better than adoption because you know the GC, but still you're worried about everything from abnormalities to what's going to happen. So you can't not be anxious. It is what is called normal. Next. The 3 questions I get, which is the end of my presentation, are these. Number 1, I get a lot of questions about disclosure to the child. And if you go on the internet, whether you're talking about ovum donation, whether you're talking about surrogacy, it is very popular to endorse telling the child early and often you don't want felt secrets. And what we have found is that that is a model that works for adoption because it's easy to explain when someone else, and now you're ours. It doesn't fit surrogacy because it's hard to explain microscopic eggs and sperm. It's hard to explain genetics. It's hard to explain how the instructions for the child work when the egg and sperm come together. It's hard to explain how you and the child share genetic history, even though somebody else's uterus was lent to you. So I say to parents, look, do whatever you want. But my recommendation is you don't have to rush to explain something the child not only hasn't asked about, but won't understand. So wait until they're looking at bellies and they're asking you questions before you try to give explanations. And here are my favorites. One, when they're very young and they haven't asked any questions yet, just make sure when you're talking about all kinds of doctors, there are pediatricians for babies and there are dentists for teeth. Also mention there are doctors that help mommies and daddies, or just mommies or two daddies, or help people have babies. So now you've introduced in a way they can understand the concept. Number two, to keep relationships clear. I would say to the child, when you are explaining surrogacy, you were 3, 4, or 5 days old, however long it was before the blastocyst was transferred. When the GC started nourishing you for us, and she did a great job. That keeps everything very clear. GC is still wonderful. You are the parents. It was done for you. And we can talk about that after if you have questions. But the good news is that the National Institute of Mental Health studies third-party reproduction, finds that 90% of children are told about it, and almost universally, they have positive feelings about it. So everybody seems to be doing a really good job. The second question, next one, that we get, particularly from same-sex male couples or single males, is should they know their mommy? And the person they're talking about is the GC. And they're usually very startled if I say, wait a minute, you spent decades fighting for the right to be two parents that are male. You're the parents. Why are you creating a third fantasy parent? There isn't. There's a GC. If she would have had a role in your life anyway, that's wonderful. If she's going to have one, that's wonderful. But children don't need, if they have two daddies, we find they don't need a mommy. That children of single parents and children of same-sex parents, if you see the stats at the bottom, are absolutely equal to children of heterosexual couples when it comes to everything from school performance, cognitive performance, and even gender identity. So you don't have to create an extra parent, and there are plenty of people, I'm sure, in the family that can play the role anyway of, grandmother of the female. And last, the question that we get a lot is, should we tell? Should we not tell? And again, cognitive restructuring. The reason so many people want to disclose to everybody is that they think if they don't, it's a stigma or a secret, or they're treating it that way. And I'm here to say it's private medical information. And if you choose to wait until the child is ready to understand before you tell everybody else, except, those to whom it'll be obvious, there's nothing wrong with that. There are no felt secrets. Yes, if you wait until they're getting married, that's going to be kind of strange. But another reason to be really careful about disclosure is that so many people misunderstand gestational surrogacy and confuse it with traditional surrogacy, where the surrogate was using her own egg. So you've got to really be clear with who you share it with, and if you do, be very clear what it is that you did. You can always tell, you can't untell, and I'm here to give you permission. Don't feel compelled to tell just because everyone says it's so good to be open. Think like a parent, do what's good for your child, and you'll make your own decision. And the last, what comes up a lot is surrogacy shaming. And we do have to deal with that. There is still a lot of negative feedback. And the two big areas, and Alexis, you might even want to talk about, is there's still a big area that they want to make sure that these GCs are not exploited, are not, seen as wombs, to be rented or hired, or not coerced. And the discussion point I typically give both IPs and GCs is the other side of that picture, is that a woman has a right to enter into a contract and make decisions regarding her own body. And that's a big, big topic now. And we talk somewhat about it. And the second area that a lot of people are having trouble with is religious concerns. They have people in their family or people they know who say it's a sin for a third party to come between two people who are creating a holy bond by creating a child. And I love to arm people with the two discussion points as follows. One is in Genesis, Sarah had her, I don't want to say servant, but had somebody who worked for her carry for a baby for Abraham. So it goes back to Genesis, number one. And number two, since IVF, it means that no other person is coming between the male and the female, because this is doing in Dr. Brower's lab or at RMA, you know, in Dr. Copperman's lab, and it's not being done in a way that seems to violate most religious concerns. So that hopefully covers some of the kinds of things that probably in your office as you're, you know, making, you're having discussions and you're finalizing agreements. Hopefully it'll make you aware of some of the concerns and some of the issues that both the GCs and the IPs are coming in with, and some of them last. But,
Thank you so much. As you guys were both talking, I was thinking to myself how many years we spent trying to convince some of the opponents of the bill that it's okay if the law doesn't prescribe every single thing that needs to happen before you get to the contract stage, because trust me, these industry, the medical industry, the psychology, it is so heavily regulated that you can tell, you see, it's exhausting before you even get to the legal part. And there are so many backstops and safeguards at each stage of the process, as you've both talked about, that it was hard to convey that, I think, a lot of the time when we were advocating for the bill, and perhaps we should have done this very program years ago, but thank you so much, because I really think it rounds out the picture of, you know, people say to me, okay, so what happens now? They come, intended parents come to my office, or the surrogate comes to my office and they say, okay, we've done, and they go through the list of everything they've done with you guys. Now we need the contract. And on the one hand, you could say, phew, the hard part's over, right? But on the other hand, now the legal stuff has to kick in. And really all of this, the medical screening and the psychological discussions and the cognitive restructuring and all this that we've talked about informs that process. And I'm so glad we did this in the order we did. I'm going to try and go fast because I know we're late, but I think you'll hear as we're talking about what are the requirements in the statute for the legal agreements to be enforceable. Now we have context for it. We understand why. So let's just go. I'm going to share these slides with anybody who wants them afterwards. So if I flip through really fast and I don't cover something, don't worry about it. But just very high level, what is a surrogacy agreement? Well, it's an agreement for the surrogate to undergo the embryo transfer, which we heard about at its basic, elements, and to attempt to give birth to a live child for the intended parents to assume legal responsibility. The surrogate and the spouse have to agree to surrender custody to the intended parents upon birth, and they will state that they have no legal rights as to the child upon birth. Now, this is consistent again with what Dr. Witkin is talking about, right? That it's not a passive incubator, but there's no parental relationship being created, and it's separate and distinct conceptually from adoption, because this child is the legal child from the get-go. There's no transferring of parental rights from one to another. There's no extinguishing. It is the intended parents are the only ones who ever had parental rights. I'm going to skip around a little bit. I apologize. These are just some of the non-negotiable provisions that you have to have in surrogacy agreement. Now, we were talking about some of the
Alexis, your slides aren't up. Sorry.
mine are still up.
Yeah, sorry to interrupt.
Oh my goodness. Okay, let me just see if I stop and it says paused. Okay. back?
Yes.
Better?
Perfect. Yes.
Perfect.
Okay, so now I'm not even on the right one. Let's go back. Okay, so among the statutory mandates, right, of what has to go into the surrogacy agreements is the provision that the contract must permit the person acting as surrogate or the GC to make all health and welfare decisions regarding themselves and their pregnancy, including but not limited to, and then here's the list, all things that you would expect under that category, whether or not to consent to a C-section, multiple embryo transfer, which you heard earlier from Dr. Brower is really not done. But again, we have to recite in the agreement that ultimately the choice of that is to the surrogate. The contract shall not, and this is statutory language here, shall not limit the right of the person acting as surrogate to terminate or continue the pregnancy or to reduce or retain a number of fetuses or embryos she's carrying. So going back now to what Dr. Brower said and to what Dr. Whitkin said, right? These discussions and these medical decisions that inform the process up until now have a reason. Why? Because the law says that the surrogate has bodily autonomy, full stop, under this contract. Any provision to the contrary is void and unenforceable. So things come up, right? Life happens. You will have to have the conversations in advance. What if, notwithstanding a single embryo transfer, you know, I'm going to botch this medically, so sorry, Dr. Brower, like it splits and you do have a multiple pregnancy. You have to anticipate for things. You have to talk about these things in the psychological setting, and then you have to contract in them. And like we all know, all good lawyers know, right? A contract is just really just codifying intent. And so while you can put in there provisions that say, you know, it is the intent, the mutual intent that pregnancy won't be terminated, you know, absent some threat. It's void and unenforceable, and you know, just remember at the end of the day, this is a leap of faith, and that's why so much goes into it on the front end before we even get to the contracting. Also, Dr. Bryan was talking earlier about how she really is the physician to all parties, and that's true. But like I talked about earlier, this is the gold standard here in New York, and part of the Surrogates Bill of Rights is that she must be permitted to choose her own healthcare provider. So for example, if she lives in Albany and the intended parents live in Manhattan, you know, they can all come to Dr. Brower and have the screening and do the transfer, et cetera. But she can say, and it will be in the provision, in the contract, and any contrary provision would be unenforceable. I want to deliver in Albany with the OB who delivered my children, for example. So, while the surrogate maintains bodily autonomy, the intended parents do have some control over the process, and they want to make sure that they have access, of course, to medical information and can participate in medical decision-making for the child during the pregnancy. And we can do this, accomplish it through provisions in the contract that allow for intended parents, for example, to be present at OB appointments. We can have a provision that there'll be a healthcare proxy signed. You know, all of these things can go in there so that it is a collaborative effort, as long as you remember at the end of the day, final decisions on medical issues rest with the surrogate. I'm going to skip just because we're short on time. Okay, expenses. This is really important. So you'll remember that before the CPSA, surrogacy was against public policy, et cetera, et cetera, et cetera. But what was punishable was if there was compensation. So this issue of compensation is where you start to flag some concerns about economic coercion and some of the things that we heard from opponents in the years prior to the CPSA. So talking about the compensation part is really important. And as Dr. Whitkin said, you know, the concept is, and then the law manifests this, that you are not paying for the child, you are not paying for the uterus. This statute is specific that the compensation is based on the physical discomfort and medical risks, the inconvenience, and the responsibilities the surrogate is undertaking. The base just conceptually, we can think about different buckets of compensation. You know, one would really be reimbursement of expenses. One would be base compensation, which is what was previously not allowed in New York. So the payments for the reimbursement and for the compensation to the surrogate must be made through an independent escrow agent. This is required by the statute, and there are other provisions about the licensing requirements for independent escrow agents. The contract has to specify the base compensation amount. It has to say that the intended parents have agreed to pay her for the assumption of medical risks, and it must be negotiated in good faith. We also have to say that the payments are not conditioned upon the number of children, you know, the characteristics of a child that's born from a surrogacy arrangement, lab error, none of that. You're not, again, we're underscoring the conceptual distinction. You are not paying for the child, you're not paying for the uterus. The statute requires, like I said, that the amount be negotiated in good faith and be reasonable. And part of, you know, one of the foundational principles of the Surrogates Bill of Rights and what this law provides is that the surrogate and her husband or partner, or if she's single, you know, has her own independent counsel, separate and apart from the intended parents. And this is a critical piece of the puzzle. I mean, up until now, we've heard there's a lot of a collaboration. Everybody sees Dr. Anat together. Everybody sees Dr. Whitkin together, and combinations together, apart. And when you get to the legal phase, which is not to suggest at all that it's not a collaboration, it is. You know, it's hard not to think about it this way as adversaries, because we're trained, a lot of us, as family law litigators, or even, you know, mediators, where the foundation is a dispute or a conflict. And really here, the point is just to ensure that there's a duty of loyalty that's being given to both sides of the contract, not necessarily to advocate for polarized interests. So outside of base compensation and repayment of expenses, which are enumerated, which have to be covered in the agreement under the statute, there are also a whole slew of very rigorous insurance requirements that the intended parents must meet on behalf of the surrogate. These are, again, gold standard in the industry. Other states that have statutes that regulate surrogacy require some variation of this, but you can see, and I'll just flip through it, you'll get my slides, that this is very, very protective of surrogates. The health insurance has to be a health insurance policy that's comprehensive, including behavioral health. It has to extend throughout the pregnancy and 12 months thereafter. That is unheard of in the rest of the country, and it's in order to protect against you know, post-pregnancy or post-termination or post-miscarriage issues that could affect her health even after. Life insurance has to be purchased for the benefit of the surrogate to the tune of a $750,000 death benefit, or, you know, in the event that she doesn't qualify for something that high, whatever the maximum amount is, and upon request, disability insurance. Some contracts also negotiate things like lost wages of the surrogate's partner in the event that she's on bed rest, for example, and you know, her partner needs to care for their kids. So you know, the compensation, reimbursement, and expenses section is going to be a real hefty part of the agreement. Of course, we have to have a termination and a breach provision like any other contract. And here, you know, the parties, like we talked about, they've been through the ringer. They've talked about it in the context of the medical facility. They've talked about it with Dr. Whitkin. They've anticipated what their intentions are, but life happens, right? And so you have to have the provisions in here that are going to say what happens in the event of breach. The law is very, very clear. There can be no specific performance, which for the non-lawyers among us means you cannot force somebody to do something just because they've said in the contract that they were going to do it. All other rights and remedies available at law for breach are available, and all other rights and remedies available at in equity. But there can be no specific performance. For example, you cannot say, and this is this should be obvious, but the whole concept is kind of foreign, but you can't say, no, you will have that amnio test to a surrogate. If she chooses not to, you cannot compel her to legally, even if she has said in a contract that she will. I'm trying to skip here for time. Some negotiated provisions. Again, you want to talk about some confidentiality issues. Dr. Witkin talked about this, but what are you going to agree on or not agree on for future contact, disclosure to other parties, and limitations on surrogates activity. As Dr. Witkin said, this is not, you don't want to think about this as like a passive incubator, right? So her lifestyle choices are going to really be important throughout the process. And so like in any other contract, you can negotiate things big and small. So you can go down to dietary restrictions, travel restrictions, etc. And up until even bigger, really, really big things. Who's going to be in the delivery room, etc. But what you can't do is, you can't avoid the non-negotiable provisions. You have to have independent counsel for both parties. She has to be able to make the decisions as to her health and welfare. She has to agree that she will not assert any parental rights. And on the flip side, the intended parents have to agree that they will assume all parental obligations immediately upon birth. So there are some foundational principles that cannot be contracted around. And I'm happy to share my slides with anybody to go through those. I just wanted to touch on a few other things that I jotted down when you guys were talking, and that was about informed consent. So informed consent, like I said at the very beginning, it is a eligibility requirement. A gestational surrogate is not eligible to be a surrogate in New York State unless she's 21 years old, meets all the requirements, including having given informed consent. Informed consent has to be given after the medical screening and the risks, both psychological and physical, have been explained to her. So earlier when Dr. Brower was talking about, sometimes with clinics, people want to rush and get the contract done, or they want to do things out of order before things. You can't do that in New York, and for good reason, right? You have to be able to recite in the contract that the screening has been done and that informed consent has been given before anything can go forward. I know I'm probably missing a million important things, but I'm happy to answer any questions by email, or if somebody wants to put something in the Q&A box now. It's a lot of information, but it's stuff we love. So thanks everybody for joining.
Can I ask you a quick question?
Yeah.
So this all applies to GCs that are going to be delivering in New York State, not a GC that's coming from Utah and having an embryo transfer in New York State, correct?
Correct. Delivery is actually not one of the real delivery is irrelevant, right? So again, yeah, you have to meet the eligibility requirements, right? So if there are two intended parents, one of them has to be a New York resident and the surrogate does. If there's one intended parent,
yeah,
that person does not have to be a New York resident, but she does. So it's a question of meeting the residency requirements and other eligibility requirements, not necessarily where things occur. Before this, right? Before this, like you were saying, that you would do transfers in other states, you would do things even if you did the IVF in New York, but you wanted to minimize the context with New York because you wanted to minimize the risk that it could ever be construed that New York law should have governed the contract.
Correct. But so my question is, right, so like you said, so an embryo would be created at NYU in the city and would be shipped out to me. I would do the transfer, like no one would ever, no physical, nothing was done like in the state of New York, everything was done in Connecticut. So my question is, do these provisions apply to a GC that's coming to me from out of state, Pennsylvania, like a very GC friendly state? I'm doing the FDA like physical and screening. I'm doing the embryo transfer in Manhattan, in New York. Does this apply to that person? Is my question. That GC.
If both intended parents are New York residents,
Yes.
and they want the contract to be governed by New York law, right? So in that situation, they would have also, if she's from Utah or whatever the state was that you're saying, right? There's probably sufficient contacts with that other state to say, well, no, we're going to have the contract governed under the laws of that state.
Okay, fine.
Yeah, right.
I don't know why any IP would ever want their contract governed by these.
Every doctor says that. It's so funny, but you know, it really is. It is a top-notch. It's a top-notch piece of legislation, and the process for getting a pre-birth order is very streamlined, not as much so in other states. There are other states where, for example, you know, you have to be married or you have to do an adoption, like Florida, for example, intended parents together in Florida, hetero or same-sex couples, they have to do an adoption for a GC. So there are provisions that are very appealing about it here in New York. What's sometimes seen as prohibitive are the insurance requirements.
I have a quick question.
And the
too.
giving her control over the entire pregnancy, a little scary too.
Yes, but let me tell you that, oh, I hear a visitor coming. I apologize for this. But let me tell you that it's codified as the Surrogates Bill of Rights here in New York, but I don't know I don't know anywhere else where you could have an enforceable provision in the United States that says that you mandate somebody keep a pregnancy. We still live in the United States, right? That's not going to be enforceable. So it's really codifying and underscoring informed consent for what her rights are, because you can get away with it maybe in other states, but you can have the contract stated and it may not invalidate the entire contract. But I mean, I don't know any other place really where you can you can say under no circumstances can you terminate, full stop.
So I have a quick question for both of you, for Dr. Brower and for you, Alexis. It's understood why the GC should have so much control over the say of her body. But suppose her decisions are counter to what's medically advisable, Dr. Brower. Suppose she's saying, no, she doesn't want amnio, or no, she's not going to do cesarean, and you know there's going to be no delivery without it. You know, what happens then?
So are you asking me?
Both of you, yeah.
Okay, well, just from the legal point of view, this is what the breach and termination provisions of the contract are going to say. So like I said, there can be no specific performance. You can't say, I'm going to take you to a court for, injunctive relief, and the court's going to say, you can't do this or you must do this. You can't do it. But you can, like any other contract, if you breach it, there can be financial penalties, right? Forfeiture things. So you agreed not to travel outside of the state in the third trimester. You did it anyway, right? The base compensation payments that are given throughout the process through the escrow agent, maybe there's an argument that there's one of the disbursements is forfeited, right? So it's a contract. You can still have remedies at law. Yeah. But you cannot get out of the obligation to continue paying the insurance and reimbursement of expenses actually incurred.
Thank you.
So I'm just looking in the chat room. Will the PowerPoints be shared? I'm happy to share mine.
Me
If
too.
you guys, okay, so you guys can send it to me and I can give it out to anybody who wants to see it, who was there tonight. Does the GC have postpartum blues / depression? Does the contract provide for care in this case? I can answer the second part of that. The second part of that is part of the statutory requirements of providing insurance coverage for up to 12 months after, is that there has to be behavioral health, but also the law says specifically that if the surrogate so requests, the intended parents have to pay for counseling up to a certain period after pregnancy. I think it's 8 weeks, but I'll have to check. Anybody else with the postpartum can, I would assume.
I'll jump in for a second if you want, which is, and Dr. Brown can confirm this, some of what you get in postpartum depression is really biochemical. There's a drop in progesterone and, you know, that would trigger those kinds of feelings, and very often it passes. And if the doctor's aware of it and the GC's aware of it, and usually they, in fact, I think legally they have to have had a child first, right, Alexis?
Not in New York. I mean, it's best practice, right? ASRM says that.
Yes, I know.
It's not.
Oh, okay.
Not required.
I think it's advisable because then they're aware of all of the feelings that pass and come and so forth. If they've had a history of pregnancy and postpartum depression, then there should be a watch. They should be aware of it, and the doctor should be aware of it, and that should be something that is expected.
Okay, last one. What are the remedies if a surrogate does something they weren't supposed to do per the contract that results in injury to the child? So we were kind of just talking about that, right? There's not much you can do. Intended parents must assume all parental obligations immediately upon birth. Doesn't matter if there's a birth defect, it doesn't matter. There's no way around that. Depending on what the breach is, right? There may be financial remedies available in terms of holding back some of the base compensation, but I would say, again, this is really a joint relationship based on trust and collaboration, and often best practice, I would think, would be, as it's happening, you know, provide for a cure period, send the parties back, just talk to Dr. Whitkin, talk through it, and you know, not resort immediately to standard contract remedies.
The more the IP and GC talk about the fact that there could be a problem with the baby before they even start, the more they're guided by what they said 9 months ago, right, and the less problem there is. And if it's never spoken about, then typically the GC feels guilty and the IP is angry, and that's when you have the lawyers brought in.
Right, and I'll just say, I'll add one more thing, and then we can sign off. But the law does require that the legal representation, independent counsel for both sides, extends throughout the pregnancy and throughout the duration of the contract. And what does that mean? That means up to 12 months after birth, termination, or miscarriage, because don't forget, there are ongoing obligations. The intended parents have to cover the insurance for up until that period. So just like you said, you're on speed dial or whatever it is, you know, call the doctor, text the psychologist, the lawyers have to stay involved statutorily. So, you know, I would hope that it would be a collaborative interdisciplinary effort.
I think we will sign off tonight. I want to thank our panelists so much. This was so interesting and such a different perspective for our bar association to have both a doctor and a psychiatrist to discuss these different aspects of the legislation together with the legal statutes. So thank you so much. I hope everyone enjoyed the program, and we will send around the slides sometime this week. So thanks so much, everyone. Have a good night.
Thank you, guys.
Thanks for inviting us.
Thanks.
Night.
Bye-bye.